Abusia and updates about Betudra efa former Buffer Stock CEO Abdul Hannan. Abusia mama yonko na yinti breaking news about and someone na ye no lawyer ede ababa tudwa Godfred Dame ede ababa tudwa emra sesia ma yinti na yenche yadwe e comment section ha ede also ye be media giche be so wase obe subscribe ede amai mobile notification bell for podcast updates ma yinti enkoma na say latest update and breaking news about emra sesia.
Everyone breaking news and say my cousin enyetete Abdul Hannan Alodeba. Yes, Supreme Court. No, sorry, is it Supreme Court? On the Okupimo Court, na jeni say omoko file share court and as a court and strike the charges against Hannan Abdul Hannan, former Fast Talk na Nipa with Jinam Edemani Godfred Dame. To say Accra High Court dismisses Godfred Dame motion to strike out Fast Talk case charge sheet order to prosecution to amend court 9 and 14 for trial to commence on July 29. Na mekasa no enye ne ye mono Godfred Dame oye the lead counsel mago Abdul Hannan Alodeba the emotion be kodan court say and communyeren almost strike out the charges against Abdul Hannan Alodeba. Now ba Accra High Court dismiss Godfred Dame motion or record no into joy news and Solomon so in regard to Chama to me. He has been on the news for some days in the internet. The latest update from the Accra High Court is a woman dismissing Godfred Dame motion or they purchase a court to strike out the charges against his client. Abdul Hannan Alodeba, former Buffer Stock CEO. You could see join news on this report. Stay tuned.
To strike out the entire charge sheet against former CEO of the National Buffer Stock Company, Hannan Abdul Wahab Aludeba, who will stand in trial for various corruption offenses. Well, this afternoon, all eyes will be on Parliament.
Welcome back to the Midday News. This afternoon, Accra High Court has dismissed an application filed by lawyers for former Chief Executive Officer of the National Buffer Stock Company, Hannan Abdul Wahab, seeking to strike out his entire charge sheet. Instead, the court ordered the prosecution to amend counts 9 and 14. Hannan Abdul Wahab and his wife, Faiza Wuni, are standing trial on 20 counts, including allegations of causing financial loss to the state. His legal team, led by former Attorney General Godfred Dame, argued that the charge sheet was fatally defective and urged the court to strike it out in its entirety. Let's head to the Accra High Court and speak to Fatal Bayaga, our legal affairs correspondent. Fatal, why did the judge dismiss the application to strike out the entire charge sheet?
So the presiding judge, Francis Apanga Chibunga, agrees with Godfred Dame that counts 9 and 14 are, which are on defrauding by false pretenses and stealing. He agrees that they are defective and that they do not provide sufficient particulars of the offenses against the accused persons, and that is the reason why he has decided to, ask the prosecution led by Deputy Attorney General Justice Rimsai to amend these counts before the return to court on the 29th of July. So basically that was what the judge said.
And his legal team is dissatisfied with the ruling. What exactly was the reaction by Godfred Dame?
Godfred Dame insisted that the whole charge sheet is vague, it is overbroad, it is duplicitous, among other things. And in fact, he said he disagrees with the court's decision that there are just two charges that are defective. In fact, he says that this particular step that he's taken is not to delay the case, but to ensure that the court relies on proper counts to be able to try his client. We can listen to him.
You cannot have various payments, the number of which we do not know, when each of them occurred, we do not know, where they occurred, we do not know. They are not disclosing it on the charge sheet, and then you say that, well, you're not going to order them to amend, and that charge is proper. That charge cannot be proper. So even though they've been ordered to amend some of the charges, we will still file an appeal. We'll file an appeal against it. But I think the decision was not so sound, with the greatest respect to the judge. And he himself acknowledged that, yes, every decision is appealable, and it's all with a view to developing the criminal jurisprudence properly. And my consideration professionally is to ensure that the rights of my client as an accused person are protected in every regard before the trial commences. It's not just a matter of delay or anything, it's just a matter of ensuring that he properly ascertains the charges that are brought against him. And no, you cannot have a sum of 15 million put together in one count and you state in the same count that they consist of several payments. Which several payments? When did it take place? Are they related? Definitely they're not related.
And that's Godfred Dame, former Attorney General and lawyer for Hannan Abdul Wahab. Moving on, 2 Ghanaians are at the International Criminal Court asking to the court.
One to me decided to give that concession to another person called Okum Henry. Now, one to me was required by the law under Section 14.1 to seek approval from the minister. And that approval is not supposed to be verbal. It's not supposed to be oral. It's supposed to be a written authorization. Now, the question you ask yourself is whether or not that written authorization was provided by the minister. From all indications, from all intents and purposes, from all that took place in court, there was none. And so clearly, one to me fell short of the law. Now, people say that this whole thing is not about Galamsey, and that it was just a matter of not complying with the laws of the land. You see, the background to this whole case must be established, as is captured in page 5 of the judgment. And with your permission, I'll read so that we get a better understanding of what we are discussing. On the 16th of April 2025, the police embarked on a special operation dubbed Anti-Galamsey. So it must be established that the operation that the police undertook was to deal with illegal mining in the Western region. This operation led to the arrest of 1 Michael Jeduayesi and 28 others in the Fmr forest within around a concession belonging to the third accused, that is Akroma mining. So the police undertook an operation to deal with an illegal mining. They entered a place in Fmr. They realized that there were some people over there doing illegal mining, and they were arrested. That is the background to this. Now, when they were the people at the site were arrested, they saw a structure there. I mean, this is how Kamuntumi's name came in. They saw a structure there with the inscription Akroma mining. So that drew some alertness for the police to do further investigation. They asked who allowed those that were arrested to be on site. Then they mentioned another person's name called Henry Okum. It was the Okum that came to tell the entire world that, yes, I was given the permission to enter that land by one Bernard Ntwimosiaku, a.k.a. Chairman Wontumi. And so the rest, I'm sure you know about it. Wontumi claims he gave the site to the person to do what we call reclamation. The guy says, no, you gave it to me for me to mine. So Wontumi's word against Okum's word. But then you come to the analysis or the logic behind it. You ask yourself whether the Okum had a license to be doing what we call reclamation or to do mining. Because to do reclamation, you needed a license called mine support. Meanwhile, he was holding a license that allows him to do what? Small-scale mining. So how could he have transformed or transitioned from doing a small-scale mining into doing a reclamation? Now, the next thing you ask is, reclamation comes at a cost. Was he, they wouldn't be paying him for doing that? It came to light in court. In fact, his own defense witness one established that yes, to do reclamation costs money. Wontumi claims that he was to plant the coconut or grow the coconut trees, and then when it grows, harvest and use the proceeds to what? Pay. I mean, does it sound for you? Okum was saying, no, this was not what we agreed. You told me that I should mine and then take some of the proceeds to do the reclamation. Between these two scenarios, I would rather go with Okum's one. So it's been established. Now, if it is established that, yes.
Why would you rather go with the Okum?
No, because the point is that, first
did they prove what he's saying, or because he's a witness in the matter?
No. It's not that. I just told you that it costs money to do what we call reclamation. Now, the Okum himself wasn't in a position to provide that money, because if you look at what took place in court, even when Wuntumi led him to go and purchase excavators, he couldn't pay all. He struggled to even pay for the excavators. How much more was he going to get money to engage in that reclamation? So if you put one and one together, it tells you that the intent of Wuntumi was not the reclamation, but to mine and use the proceeds to do this. And so once it has happened that this way, that you gave the land or the site without the authorization, the next thing to do is whether or not it frowns on the law. That is what section 14.1 says, and 99.2b also deals with. So in terms of how the judge arrived at a conclusion, they say they have identified about 20 grounds of appeal. The right to appeal is germane. You can do it at any given time. Their legal right. I want to see the appeal that they put forward, and we all will be following through.
Okay.
But I was reading your headline, and I saw one of the headlines saying that this is political. Wuntu is a political prisoner. Is that the case?
That's what the NPP believes.
Why not? But can you give me the definition of who a political prisoner is?
If you check it on Google, it has a clear.
So check your Google and let's go through and see. This morning we are doing.
We'll go to the person. We'll go to the people who purport it's a political.
No, assist me.
Yes.
So that I can.
And then we'll go to them.
So let me assist.
When I come to him,
I was going to assist him.
We would come to him because it's a question he needs.
Of course, but the point is that.
You want to land on you.
So the point is that from where I sit, anybody that says Wuntumi is a political prisoner is being economical with the truth. First of all, was the issue a political issue? Wuntumi went to court, he was charged, he had his counsel, he brought in defense witnesses he called for, he was allowed to go through all the processes without being truncated, and at the end of the day, there was a judgment on the matter. So where lies the political prisoner? Where lies it? We must not be mixing the two together. And that's why I thought that was a political miscalculation, what the MPP did. Because now the impression that they are creating out there is that when you do something wrong against the state, in this case, Galamsey, that has caused close to 4 million Ghanaians to contract kidney problems, because you wear a political color, you must be allowed to go off the hook. So how would the MPP in 2020 go back to the Ghanaians and say that they will deal with the issues of Galamsey when they are rather protesting against an incarceration of one of their own? I will leave it here and hear from my brother Ben what he makes of being a political prisoner.
I have some.
I've been reserved for the last lot.
Yes, so I'm coming to Hamza.
I've been reserved for the last
Who
lot.
reserved you for that?
She reserved me for the last lot.
I did.
On what ground?
Hey,
She decided.
I
Are
did.
you questioning
Look
the
at
holds?
me. I did.
Yes, she did.
I kept him for the last
Then
one. No, it's not.
I would decline the invitation this morning on a simple principle, and I'll
What
explain
principle
why.
is this?
I do not speak for the judiciary of the Republic of Ghana. I speak for the National Democratic Congress. The National Democratic Congress is not in court as far as the Wuntumi case is concerned. And as far as we are concerned, if there are consents, the appeal processes are there for the Wuntumi and his legal team to take advantage of.
Okay.
However, if the NPP runs commentary on the matter, an invitation then is extended to me as a government spokesperson. If they run commentary and they make it political,
They have.
then I'll be in a position to respond to the concerns that they are
I've not asked
raising.
you your question yet. I've not asked you.
So really,
No,
you should
no,
have
no, no,
started.
no, no,
So that's the point I am making.
relax.
She said she asked me
I
questions.
haven't.
She said she asked me questions.
I
So let me
haven't
listen.
asked
Let me
you
listen.
Please be
question
fair to the
yet.
host.
I came to you first.
So
I said I'm coming to Hamza.
I've
not asked him a question, so I don't know what question he's
But
answering.
in fairness,
Who is answering?
No.
I'm coming to you. I've not.
Leave the moderation
I'm not
for the
answering the
host.
you don't have a
I'm
problem. I
stating
mean, you can go. You can go.
So what's the position? You don't want to comment on?
I was trying to understand. I don't know what to comment on.
No, because I
wait
haven't
for your
asked
question.
yet.
Wait wait for your question.
Because you said you are reserving for who to respond to the concerns that he's coming to.
Wait
because
for
you're
your
going to play
question,
politics.
Hamza.
Is he a lawyer for
I'm not sure what's going on this morning already.
I'm even surprised.
No, is he a lawyer for Wuntu?
No,
I'm
guess
not.
what?
But wait for your question.
Guess
Please
what?
wait for your question.
When
Well, let's proceed.
Solomon
Let's proceed.
ended, he sought to throw the baton back to him, and I said, no, he can't choose who speaks. I will choose who.
But really,
She's in
And
charge.
I'm saying
Yes.
that I want to go to Hamza. Hamza
because the
should
matter
wait for my
concerns.
question.
Listen,
Why wouldn't you
I
wait for Hamza's question?
referenced a
It's
statement
okay.
that had been made
Let me.
By the
NPP.
political prisoners. You said
Yes,
they see
and
us,
I
I'm
was
saying
seeking.
that.
Let's not drag it.
And I'm saying that I have questions
Yes.
for the lawyer over there.
Yes.
But in the meantime, I'll go to him later.
Understand.
I want to come
No
to
problem.
Hamza.
Yes.
Hamza has made it very simple. He'll
No
respond to what the other political party has on the Chairman Wontumi matter.
Yes.
Makes it very simple. They assert that they perceive he is a political prisoner. Is it something you agree? If you don't agree, what are the reasons?
First of all, I think I've made this point on another platform, and it is important for us to put it in perspective. The most difficult decision, the most painful decision for any president, for any government, for any attorney general, is to have a citizen, regardless of political party persuasion, thrown into jail. It is not a pleasant experience for any president with emotional feeling. It is not a pleasant experience for any party that cares about its citizens. It is not a pleasant experience for anybody appointed into the office of Attorney General or Deputy Attorney General. And so that point needs to be made. However, necessity requires, and for the sake of democratic stability and accountability, that from time to time, these painful decisions would have to be taken by a president, by a government, and by the Attorney General's office. It does not mean that we do not recognize the implications it will have on our citizens and their family. And so on the basis of that, I can understand the pain of Chairman Wontumi. I can understand the frustration of family members of Chairman Wontumi and what this verdict would mean for them. Same pain, I can appreciate government's dilemma. The need to ensure that you do not have your citizens thrown in jail, regardless of their partisanship, but also taxed with the constitutional responsibility of ensuring accountability and ensuring that there's semblance of sanctity when it comes to our democratic space. And so that point needs to be made. And that is why I do not think that this is a political prisoner and this is partisanship, because this is not a victory for the National Democratic Congress. This is in pursuit of sanctity on behalf of the Republic of Ghana. And so that point needs to be made. MFR, my brother made references to the legalities. I've had the benefit of reading the entire judgment. And I can also declare on this table, but with a caveat, I'm not a judge. But having read that judgment from the lady judge, they say that women are known for how meticulous they can be, especially when it comes to the application of the law. Having read that judgment, I struggle to appreciate where the so-called over 20 grounds of appeal Atachia is speaking about is going to come from. And I'll explain to you why.
Okay.
First of all, when the judgment was read, the NPP released, Minority in Parliament released a statement, and they made references to 3 grounds, based on which they refer to it as politically influenced. The first, they said that Wontumi was denied counsel. He didn't have access to counsel. An obvious lie. Deception, intending to hoodwink many of us, especially unsuspecting citizens. Why is it a lie? We all know that the Honorable and the Apia Kubi was the first counsel for Wontumi.
In fact,
From when he was arrested.
Godfred Dame started.
Well, so from when he was arrested at Ioko, it was Andy who was leading the charge, the Honorable Andy. Then subsequently they were in court. Godfred took over, handed over to the Honorable Andy Apia Kubi,
Yes.
who proceeded only for us to be told by the judge that indeed ruling was to be given on the 3rd of July, 2026.
Four.
Right?
I think it was 4th.
It was 3rd.
It was 3rd.
It was 3rd of July, 2026. For some strange reason, Andy decided to recuse himself or to resign from being the lawyer to...
He gave his reasons. He